month in 2025. Yes, indeed it is. Now, for this hour, we're talking about judicial reforms as Nigeria marks 65 years of independence. As we commemorate, as our country rather commemorates its 65th independence, the state of the judiciary remains a focal point of national discourse despite significant strides since 1960. The judiciary continues to grapple with challenges that impede its effectiveness. Chief Justice of Nigeria, CJN, Justice Kudirat Kekere-Okun, has advocated for comprehensive reforms aimed at enhancing the judiciary's efficiency and independence. She emphasized the need for legislative support to strengthen anti-corruption measures and streamline judicial processes. Legal experts have also expressed concerns over the prolonged duration of legal proceedings in Nigeria, notably constitutional matters, raising questions about the judiciary's responsiveness to urgent national issues. So as you can tell, there's a problem. What happens with problems is possibilities follow and hopefully solutions meet those problems. But I'll be speaking with my guest, who is a legal practitioner, as you can imagine. But the focus for this conversation is expansion of judicial infrastructure, technological advancement, but most importantly, access to justice. My guest is Chief Festus Oguche. He is a legal expert and analyst and our go-to guy for these kinds of conversations.
Thanks for inviting me.
It's always a pleasure. How are you doing, sir?
I'm all right, very okay. We just celebrated the independence anniversary, low-key, but we did it all the same. We thank God for it.
Okay, I'm glad you started there because you had a couple of thoughts about the president's address, what he said in his broadcast. Matter of fact, let's play what you said before we get into this conversation.
The president is not true to himself, and if he's true to himself, then he's not speaking to truth on the conditions of Nigerian citizenry in terms of their ability to take care of themselves, to fend for themselves. Go along the streets and see hunger, poverty, starvation reeking all over the place. Excruciating poverty is on the ground. And
now, you also faulted the development index presented by the president, insisting that many sectors are in decline, security is getting worse, and all of that. This interview was very likely yesterday. Of course, it was for independence. Between yesterday and now,
Yes.
have you changed your mind? Has
No, I
anything
have not
changed?
changed my mind because when I listened to the president's broadcast, I expected maybe some bit of speech that to be assuaging of the hunger and the starvation that people are going through, but he was there reeking out figures and making it look as if we are very close to El Dorado, and I know that we are very far from it. So we have to tell truth to power because the president is not making a good representation of the actual reality of things going on. And I blame that on his handlers because if you're in the cozy ambience of the Asher Rock Villa, you may not be able to know what is going on the streets of him, but particularly when it comes to the food on your table, because you're fed free of charge. You take anything you like. You're the person in charge, so it doesn't affect you much. But then I think sometimes some of these leaders have to step their feet into the shoes of the ordinary man to know how they pinch, particularly in times like this where everything is just austere. It's gone beyond austerity now, and I think the poverty level is very excruciating. I wonder how people can wade through the difficulty in the days ahead.
Well, Chief Oguche, many presidents around the world use their Independence Day speeches for what you might term a progress report. This is how far we've come. It's an opportunity to celebrate their wins. If our president uses that to highlight the gloom, whether or not you support him, that has to be an out of place speech.
I'm not talking about using to give pictures of doom for anybody, but at least some bit of hope about things, but then placed against a backdrop of the current reality of things on ground, not on falsehood, not on conjectures, not on high-falutin figures showing that Nigerians are doing very well and it's El Dorado and we are flying the moon, whereas we are still there, deep in the ground. So that's not the appropriate thing to do. I wouldn't expect it to be a broadcast of doom, but then the gloomy picture has to be painted as to how the things are and what actually is on ground, so that people will understand, that the authorities understand the situation on ground and what the people are going through, and maybe try to give them some bit of hope that we are working on it and just be patient. It's a matter of time. But it came sounding as if we are just flying the moon and going all over the place and Nigerians are okay and Nigeria is okay. Just like he told the Brazilians the other time that there's no corruption in Nigeria anymore, which it's a blatant lie.
The president is the number one public relations officer of the country. So selling this country well should come naturally to any president. So I will not exactly blame him for telling people outside that we're doing very well.
I agree. But doing that brazenly will also attract very scathing comments from us.
Yeah, true.
People like us who know a lot and who know better.
And in a democracy, those comments are very much allowed. Okay, so let's start by placing the judiciary on the hot seat. Chief Oguche, Nigeria has only had two female chief justices. Just two. Justice Aloma Mukhtar and the current CJN, Justice Kudirat Kekere. Is there a reason behind this?
I don't think there's a reason behind it. They got it purely on merits. I know that in some states they bypassed seniority of judges to appoint chief judges of state.
That's it, yeah.
That one is more endemic here in Rivers State than ever. They can bypass 5, 6 and bring somebody from behind. But all through the federal judicial structure, it has been on that line of seniority. And I think they got it purely based on merit, yes.
So will this, because if we've had people, right, both male and female, who rise to the very peak of judicial practice, has there been a decline in women getting into studying law? Because you have to look at the numbers. Yes, it's based on seniority, but do we have more men than women? That would explain why we've had over 20 men and just 2 women. Is there an imbalance?
I don't think that is the issue, because if you recall, those people like Mukhtar and the current Chief Justice of Nigeria, they were called to the bar very many years ago. And at that time, a lot of people were not actually going into law. Very few of them. We had some of them, prominent of them. The Honorable Justice Gay was there, and very prominent. But it's not just a question of imbalance. But I think the manner things are going now, very soon we are going to have more women in the profession than men, because everybody aspires as a women's profession, and I think it's a welcome development. But as at that time, they were called to the bar in the 70s. I don't think any of them, including the current CJN, was called to the bar in the 80s. I think it's something in the late 70s or something like that. Okay. That time there were very few women in the profession. There were actually very few lawyers. It's not like what is going on now, that you have a whole lot of people now aspiring into the profession. But it has nothing to do with gender discrimination or gender inequality. It is just a matter of the flow of what is on ground.
Okay. So at this time, the president plays a huge part in the appointment process of the Chief Justice of Nigeria. And of course, recommended by the NJC, but, there is the input of the president to a degree that is undeniable. Now, if we're talking judicial independence, should we have a system where the executive is not as involved in the appointment of a Chief Justice? Will that help in any way?
No. If you look at other traditional democracies, for instance, the United States, you cannot insulate the executive from what is happening particularly in terms of appointments in the judiciary. In the United States, a lot of the justices, the judges of the Supreme Court, are appointed by the president, and there are some where the elective principle comes into play, where they vote. That is not our system here. But you look at it from the peculiarity of our own situation. that in most crimes, for instance, in the United States, majority of judges that were against, that are even currently against President Trump, they are the point himself. This person put me into this sort in their decisions. They look at it point of view of law, of jurisprudence, of objectivity, of fairness. It's not like that here. For us here, it is he who plays the piper that dictates the tune.
Yeah.
And for that reason, we are saying that when you are dealing with extraordinary circumstances, you apply extraordinary solutions to it. In our own crime, majority of the people that are put into office by the president, as the CJN, by the governors, as the chief judge of Rivers State, are expected to kowtow to their whims, which is not supposed to be. And that's where the destruction of justice emanates from. So we are saying that the judicial mechanism, you don't have to tie it responsible for fund, for instance, or even discipline, and to the operation of the judiciary. You know, a decision was given today by Omotosho, and people are talking about it. We're not going to the nitty-gritty of that one. But then I think for us, a wholly independent judiciary is ideal. Independent in the sense that the judiciary can function by itself, can regulate itself. It's made up of noble people with high practical and intellectual ability that can run their affairs. Within us as lawyers, we know the lawyers that are capable of running judicial affairs, the lawyers that are capable of being appointed into judicial offices, those of them that have seriousness, that have integrity, that have made their mark in the profession. So it stand the test of time.
Okay. You can't talk independence without... What is the framework for funding of the judiciary at this time?
Well, President Buhari had done something spectacular, and it's worthy of commendation. I'm not one that's readily commend him because I never liked his style. But for that, I think I did that. He came up with an executive order that the funding for the judiciary should be charged upon the Consolidated Revenue Fund, and it be distributed to the heads of judiciary of the states. Something like that. I don't know to what extent the implementation had been done.
So they're supposed to get the money directly?
Directly to themselves, or run their affairs, run everything. They are being not answerable to anybody. You know, and when that happens, then of course we expect that there'll be less intervention of the executive in the affairs of the judiciary, like purchase of cars and buildings and all that, because enough fund has been earmarked for them for that purpose, so that we don't have a judiciary that is strangled between the judicial system and the people and the legislature, and, you know, it makes democracy look bizarre and weird.
Yeah, I'm glad you brought that up, because that was going to be my next question. The largesse enjoyed by judges, you know, we have seen. And, you know, the amazing thing about it, which I don't know how to feel, it's not the kind of thing that should make news headlines.
No.
But when these gifts are given, the media is called to cover the event.
Yes.
Right? Where some judges are gifted houses and SUVs. And you're like, the way I know that this should work, this is out of place. So the fact that you're making a show of it shows that there's a lack of understanding of how things should work. Or maybe you just don't care. So we've had that culture. And, well, River State is way up there when it comes to... You know, that I know there are many other states that do not do that. But since this has become what I would term a political culture, because it's a habit now. Well, I don't even know if I should say how should we stop it. But some people might draw inspiration from that. Some executive official and say, hey, if it has happened here and happened there, it's important that we make our judges feel comfortable, because that's the line that is used. So what's your take on that, even though you've already shared a bit of your perspective?
Yes, I've expressed my position on that point, and I don't think judges are not undeserving of those largesse. They deserve it. It's not easy to work, to deliver decisions, make decisions, sit, adjudicate, and they still use longhand. So the technological advancements that we witness in foreign jurisdictions, where court sit, it has not. They have not trickled down to our system here. And they are deserving of that. But I think it's the mood of giving that kind of thing. If it's coming directly from the governor, from government house, or from the state executive, or the federal executive, I question it. That's not how to go about it. You can impute it into whatever is their allowance, whatever is their take home, their perquisites, and all that. Factor it into it. The state government can do it without getting anybody to know that it's coming from maybe a largesse, let me use your words, from the government house and from whichever authority. Because the judge is supposed to be independent at all times.
Yeah.
We cannot joke with judicial office. Judicial positions are such that are very important. They have the power of life and death.
True. Literally.
That's how it is.
Yeah.
And there are no two ways about it. I'm talking about even the superior courts that determine the fate of a country. That if you come to a place like Somalia and you see everything beginning to fall, the first place you point your fingers at is the judicial system, because law is an instrument of social engineering. And in playing that role, it means that everything must be placed on the scale of perfection, scale of justice, subjectivity, that justice thrives in the land, and that kleptomaniacs are not given any chance, and people who indulge in all manner of vice are not given any position in public offices, and that things work the normal way. It's only the judicial system that will guarantee that, and nothing more. It's not the legislature, it's not the executive. In most democracies, in most jurisdictions, what you find is the proclivity of the executive trying to maneuver or control or manipulate the judiciary. That is exactly what is going on in the United States now.
Okay.
So it's not peculiar to us. But the key thing is the extent to which you can douse those inclinations, to the extent that the judiciary cannot be interfered with. Once you begin to see that interference in the judiciary, you have problems like we have here in Nigeria, that the totality of everything that is going down in our country can be placed squarely on the shoulders of judicial failure.
Okay. We take a break. After that break, we talk the reforms. What reforms would be required to strengthen our system? Stay with us. 90.3 Nigeria Info. Sam Chinedu here. The CJN has called for judicial reforms as Nigeria marks 65 years of independence. My guest is Chief Festus Oguche. He's a legal expert and analyst. You're welcome once again, sir.
Thank you very much. Thanks.
All right, we've been having conversations looking at the different parts of the judiciary. But now to the main question. What particular reforms, and I know that this question packs a punch because the answers should be the gift that keeps on giving. You can never really exhaust all of it. But what particular immediate reforms are necessary to fix the system?
Well, I think it borders on areas that have to do with public interests.
Okay.
Elections adjudication, political matters.
Very important.
Very important. All other areas like land matters, family, we have a highly developed jurisprudence and case law in those ones, and I don't think there's any point varying them, except maybe when we make up our mind to discard with the Land Use Act, if finally we want to do so. But apart from that, every other area is well taken care of. Fundamental rights is very, very apt, and the procedure is very commendable. The new rules made by the Chief Justice of the Federation on the enforcement of fundamental rights. Then we also look at it from the point of view of the international courts of which Nigeria is signatory, or which Nigeria has ratified its treaty, like the ECOWAS Community Court of Justice and the African Court of Human Rights, holistically. But then the core area of reform is in the post-election adjudication, which I think has left so much to be desired, and that's the centrality of everybody's disenchantment with the judicial system. I'm so elated that the Chief Justice of the Federation was the very person who recognized that there's need for reform. And so when we begin to talk, they'll know that we are not just talking from nowhere. And the electoral reform is one that I think we have to understand it from the point of view of the role of the judiciary. I told you earlier today that the law is an instrument of social engineering, and it's there to cover loopholes and gaps, inadequacies here and there. Where they are there, you can have a wholesome legal document that is perfect. There will always be ways of picking holes with it. But then when it comes to elections, you discover that it's the courts, it's the judiciary, the tribunals and the Supreme Courts that look for the loopholes to pick, to discard with election petitions, or to discountenance petitions bordering on complaints on elections, card reader, declaration of results from the place of polling in real time and all that. These are things that maybe I think the Supreme Court will have to wade in. It's not just a court of law, it's also a court of policy. And when we have these inadequacies in the system that creates room or avenue for people to engage in malpractices, electoral malpractices, electoral haste, electoral manipulation and maneuver, the decision of the courts can come to fill in the gap. And that's exactly what the courts in Norway are doing. In Sweden, most of the Scandinavian countries, that they don't wait for reforms.
Okay.
They don't wait for reforms. We don't need to go into reforms. It's for the courts to, in their decisions, block all the loopholes.
Okay.
Ensure that standards are created.
Self-police.
If, for instance, there's nothing in written law, black and white, that tells anybody that, well, the elections must be broadcast from the place of polling, the courts can create that. And thinking that maybe you have to. I can bet you that I can do all your reforms in law reforms and amendments and reforms and everything you want to do. There will always be loopholes. And we have a situation where it is the courts themselves that are looking for those loopholes to discountenance elections.
Okay, so that's
fraudulent polls.
As amazing as that sounds, when the court creates it, and I'm using the example you gave, what is it called? Because the process of lawmaking is in the jurisdiction of the legislature. So when the court sees that loophole with the Scandinavian countries, and then create, what is that? Is that a law? Is it a policy? What exactly do we call that?
They call it realism.
Realism.
And it is part of our practice that whatever the courts say and nothing further is what the law is. It is not looking at the statute books. It is not looking at the provisions of the law, but the pronouncements of the judges.
Yeah, but
That's American realism. It's part of our practice.
if it is the ruling of a case, right? So there's something before the court. Eventually, there's a verdict. We also call that law. But in this case, it is self-sanitizing, right? Self-policing. And then it finds a loophole and then creates a system to check it. Does that constitute, like I'm looking at the process as I know it to be.
When there's a lacuna,
Yeah?
there's a gap in the law. It is not the business of the court to fill it.
Okay.
That is number one. Oputa, Justice of the Supreme Court, fantastic jurist, has said that. But there are instances, circumstances where the court will have to rise up to the occasion,
Okay.
in spite of the fact that what it is doing, basically at that time, is referred to as activism, judicial activism.
Okay.
To plug any lacuna, to block anything that will lead to an absurd decision. For instance, somebody that is known very, very well to have lost an election, coming to win it, because the other party was not able to file his own petition within the period allowed by law.
Yeah.
These are the functions of the court. That's why we have the Supreme Court. And that's why we say that it is not just a court of law, because it doesn't have to look at the law to interpret or
Yes.
give its decision.
Because at that time, there's no
It's
existing law.
It's a court of policy.
So when that decision is taken, it is contained in what document? I'm trying to look at the academic perspective.
It is contained in the judicial decision, the reasoning of the judge, which surpasses the legal document, which surpasses the statute.
And there can be reference to it.
Yes, they call it American realism. It's part of our practice. You come to court and find a very bizarre situation. If you follow the law, it will lead to an absurdity. What do you do as a judge? You follow the one that connects with reason. And that's what we are saying, that is the role the Supreme Court should assume on itself. And not to be the one to look for loopholes or pick for this and that the entirety of the jurisprudence of elections anywhere in the world is to ascertain who scored the highest number of votes, not who was there when it was pre-election or when it was post-election or when Mr. A was coming and he was not able to file his process alongside with the statement with the statement on oath, the witness statement on oath, alongside with this, or not only so that he has complied with the Electoral Act, not the Electoral Act. The compliance must be with the votes cast. That in most elections, in modern democracy, election adjudications, tribunals or the courts ask for, and they count that the centrality of.
Okay.
And that's the core principle of the election on head in Accra about 50 years
So
ago. That the centrality of
common. So American realism.
It's not just looking for what the law says or what the law says it ought to be, pertains or panders to justice.
Do you see why many people think the judiciary is the source of many confusions? Or maybe I'll just I get the point, right? But when a person does a lot of things by the books, they fail to adhere to whatever is not in the book.
I'll give you an example.
Right?
Do I give you an example?
By all means. By all means.
In DSS against Sadbakoba, his passport was seized.
Okay.
And it came to the definition of what amounts to his rights as per the passport. And it's not defined anywhere in the law. The Supreme Court went outside the realm of the statute books and said that the right of him to own the passport translates to his right of ingress, entry, and egress, departure outside the country.
Okay.
Are you following me? Mm-hmm. It has coined its own jurisprudence now. That holding a passport means you have freedom of movement to move into the country at any time.
Yeah.
And that is also the case law that established that the Constitution cannot take care of all the enormity of all situations.
Naturally, yeah.
So what will the judge do in interpreting constitutional provisions where there's a gap?
So
American realism comes in to tell you that you can go doing your judging, but where there's a gap and the gap needs to be filled, you look at the law, you look at morality, you look at justice, you look at objectivity.
So would it be
all
safe
put together?
Would it be safe to upgrade the profiles of judges to occasional lawmakers as well?
Well, lawmaking is part of judging, of course, in abstract jurisprudence, though you don't apply it very often. But when a situation comes between maybe the conduct of elections in a particular place, and you know very well that this person had done this and that, and he runs quickly seeking for judicial intervention to get him declared as the winner of that election. When you know very well by the processes before you, by the fact of the evidence that's been taken so far that he didn't win the election, you apply extrajudicial thoughts and decisions in arriving at the conclusion of the matter.
Okay.
If you follow the law is very static. That's why they say it is an ass. If you follow the law, it could take you to absurd and absurd conclusions, insuperable conclusions. So you must discard the law in that sense. Not discarding it in the sense that you're still applying it, but applying it with a humane disposition, with an extrajudicial disposition, as a judge, as a social engineer, and as an authority that will dispense justice in its full elemental forms.
Amazing. All right, we'd like to hear from you. We're talking judicial reforms. What needs to be done to bring about a better working system, especially as Nigeria clocks 65 years of independence? Call us 0817-923-02, 017-923-03. WhatsApp, it's 0903.
That's why it's for the churches.
Okay, Matthew.
But Oracle, what I'm saying in effect is, look, not that the laws cannot be applied. The laws can be applied sometimes to allow justice to sail.
Completely. Yeah. Okay. Cosmos says the problem we have in the country is that we have kleptocrats in all sectors of the country. Okay. We'll be taking a call shortly. Rivers people are not surprised from the verdict of Omotosho Fidelis Elemoa from HA says. The next comment reads, Judiciary has always been the problem of Nigeria. Judiciary have constitutional obligation to hold every other arm of government to account, which they fail to do. Onishi Ejiofro from Mile 3 says. Promise from Rumo Dumaya. Hello, Promise. Good evening.
Good evening, my brother Sam.
Good evening. Greet you too.
To me, I believe we are heading somewhere, and the only way we can achieve that, I think the more we make mistakes, the more we keep learning our mistakes. So there's no magic or abracadabra can do now. Countries like America today, when I go back to when they were 65, I discovered that yes, Nigeria is really trying. When it was 65, that's very on the 1st of October. What I did was to refer back to countries that are developed today and how they were, and I discovered that yes, we are trying. The more we make mistakes.
Oh my. Okay, Promise. Thank you very much. Ezekiel calls from Ubimini. Good evening, Ezekiel.
Good evening, SOC, and greetings to your guest.
Good evening.
SOC, if I may ask, according to Omotosho, who said that the 5 men have no legal right to apply on any issue concerning the state of emergency. If the court knows that, why did they attend or accept or even try the case?
Okay.
I don't know if you understand me, Mr. SOC.
I understand perfectly.
Because it is unfortunate for them to tell us that they don't have the jurisdiction to attend or entertain the matter rather than the Supreme Court. No, that is why. No, we cannot entertain this case. Go to Supreme Court and file your suit.
All right, thank you.
They're telling us that they don't have.
Oh, sorry. Thank you, Ezekiel. My guest was going to get that question as well. Alex calls from Onelga. Hello, Alex. Good evening.
Good evening, Mr. Jose.
Good evening.
I equally greet your guest in the house there.
Yeah, thank you very much.
Thank you very much. The way both of you have digested everything that we are talking to this. But my question is this. Having realized all these things, that has been a very loophole and been a very thorn in the flesh of Nigerian judiciary. How possible, the way I'm looking at it, will the judiciary be able to carry out all this reform that is expected of them. Because the way I foresee the country going judicially is not moving the direction the people want.
Okay.
Rather, those people that are up there, as you said, are representing the interest of their masters. What reforms could be actually applied that can make it work as fine?
All right.
My question. Thank you.
Thank you. Thank you very much, Alex. Atuebu is asking questions around we spoke about earlier on WhatsApp. Should Constitutional Court not be proposed to handle electoral matters like the impairments that the emergency rule suspending democratic institution is left unattended to till its enforcement because of no effect? The judiciary should be held responsive to adjudication of the matter at stake. And this question says, what are your views on the state of emergency declared in River State? Do you deem it constitutional? Okay, so lots of questions connected to the state of emergency, but let me start with the question a caller asked earlier, which I was going to ask. For situations where a court claims that it does not have jurisdiction over a matter, what we see is that it takes all of the time it possibly can to tell the plaintiff, no, we can't have this case. Wouldn't it have been better to have a system where before it even makes its way in, the court rejects it because it's not...
You'll find that in the international courts. If you apply to, say, the African Court of Human and People's Rights in Tanzania, and then you bring an application at the registry level, they'll look at it and take a decision on it. And so also with the International Court of Justice and the United Nations Human Rights Committee and the European Court of Human Rights, not in domestic court. It is proper. It is ideally proper that way. To some extent, with the new rules of the River State High Court, they do that to a large extent. If at the registry level, the matters are assigned to some officials who look at it, and if there's any jurisdictional defect, they'll point it out. But then he talked about the 5 members, and the court apparently raised the issue of locus standi, the capacity of the persons to bring the action before it. And I was wondering whether Nigerians do not have capacity anymore to bring constitutional questions for determination. But then the court has the right to exercise its discretion in whichever direction it wants. But then it's judicial procedure. That's how it should go. And I think the focus be on judicial reforms, more on judicial reforms than law reforms, because we have sufficient laws to cover every issue, every area. If you look at the Constitution itself, people are clamoring that maybe we should go for a brand new constitutional making process. If you look at the EFCC Act, the criminal, we have sufficient laws. It is the attitude of the exercise of the discretion by the courts that make the law look somewhat how do I describe it? But it's becoming somewhat a problem. And you have a problem really when public confidence has gone down the tolls with regards to the extent to which they can hold the judiciary responsible to its mandate. The reform should be on judicial reforms so that we have a new crop of judges that will come with an attitude that will pander to justice, pander more to objectivity, and not to the interest of state, not to the interest of the president, for instance, not to the interest of the people in an authority, as to create that balance that will give it that form of a humane judicial system that will meet the expectations of the people.
All right, let's take this call. Has to be the final one from Obed. Good evening, Obed.
Good evening, Mr. Sam.
Good evening.
And good evening to the legal.
Thank you.
Good evening, sir. Mr. Sam, I think the reform of judiciary, we might not to have those who have lose rank.
Please turn off your radio. Please turn off your radio.
Normally, for you to see a judge, to know judge face to face, because they say you don't see them any because of the who. But this time around, we have seen judges being appointed, having close relationship to those in authority. So I think all this can accumulate to what we are having currently. That eroded the public confidence on judiciary. So I think, or if you tinker on this line, it's going to go a long way, where judges cannot be appointed anyone who has a close rank with those in authority.
All right, thank you, Obed. I was trying to get you to turn off.
It raised a very important issue, which is the recruitment process for judicial officers.
Yeah.
For the past decade, it has been a story of dismal failure in appropriating the right kind of recruitment process that will bring credible persons on the bench. There's been a lot of talk about it. My Lieutenant Carlo had done extensive work on that, able to maneuver positions amongst the judicial officers existing about that time, top judicial officers trying to find their kinsmen, their proxies, their children into judicial positions, which is a very bad development as far as I'm concerned. But there's one area I want to talk about, which is the disposition of the Nigerian state to disallow its citizens from accessing the African Court of Human and People's Rights. That court is created. It does not exercise disciplinary jurisdiction on any domestic court, but it can, for instance.
It can?
Yes, the Court of Human Rights.
Could it be for the avoidance of abuse of the court?
It could be for the avoidance of justice.
No, for the avoidance. Why you're restricting citizens from gaining access so that they don't abuse the court?
It's not abuse. Who abuses the court? We have access to the ECOWAS Community Court of Justice.
Access to the court by everyone.
You see small states like Togo, Benin Republic, Ghana, their citizens have access to those courts. And apparently that's the reason why you seldom find election disputes in courts in Ghana. Because, that court has the power, for instance, the jurisdiction to determine election questions, because elections are part of the human rights framework. Before you access that court, EFCC violates your fundamental rights, for instance, you have to go to the Attorney General, who will now take your case there. The same Attorney General will represent you and represent the Federal Republic of Nigeria and the EFCC that violated that right. So it's a situation that Nigeria denied access to justice. But I think events will happen very make us go into discussing it. Even at the United Nations Human Rights Committee,
you're preempting events that
Nigeria declined to ratify the Covenant on Civil and Political Rights. So Nigerians do not even have access to the Human Rights Committee of the United Nations. So why are they doing this to us? Okay. And people are not asking questions because they know much. If a lot of the state of emergency in Rivers State is something that could be decided by the court in Tanzania.
Yeah. That
aimlessly.
That would have been the first port of call, actually,
exactly.
if there was access to that.
Exactly.
Finally, Chief Oguche, and very quickly, because we're out of time, access to justice. Many Nigerians, especially the poor, find justice increasingly inaccessible for lots of reasons. But high litigation costs, systemic inequality. Sometimes somebody even calls radio to state a problem and you tell them, no, go talk to a lawyer. And on the spot, they tell you how close to impossible it is for them to get. Very quickly, sir, what reforms are required to get the common man access to the arm of government that is designed to defend the common man?
It's a constitutional provision. It's also a fundamental right that you must have access to courts to dissipate and ventilate your complaints. And when you are denied that access, it's something that you can go to enforce. That is why at the ECOWAS Community Court of Human Rights, you don't pay any fees. It's free. And we are saying that some of the jurisdictions charge very high fees, including they have to go institution to understand the nitty-gritty of issues pertaining to the extent to which these rights are given to people to access justice by easy entrance into the array for the ventilation rights.
All right, thank you very much, Chief Oguche. It's always beautiful doing this with you.
Thank you.
Thank you for making the time.
Thank you for your hard-hitting questions. Very
Apologies.
hard-hitting questions, I must confess.
All right, so 5 o'clock is upon us, and the news update happens at the top of the hour. After that, we'll be talking to the local government chairman of Obiakpo about land grabbing. Stay with us.